Next, we move to the current status of Measure T. The request for a temporary restraining order against Humboldt County was denied in a hearing in U.S. District Court yesterday. Judge Alsup of the Northern District of California refused to suspend Measure T and instead clarified the limitations on the participation of Mercer Fraser Corporation and O&M Industries in upcoming election activities. The Pacific Legal Foundation filed the lawsuit on behalf of Mercer Fraser and O&M Industries to challenge Measure T, charging that it violates the company's constitutional rights. Measure T bans campaign contributions from non-local corporations. Voters passed Measure T into law 2 years ago after Pacific Lumber and Walmart financed 2 separate political campaigns. The legal challenge against Measure T is set to continue in a hearing on Monday, September 22nd, in which District Court Judge Susan Ilston will hear the Pacific Legal Foundation's argument for a preliminary injunction preventing Measure T's enforcement. Caitlin Sopoci-Belknap, director of Democracy Unlimited of Humboldt County, one of the local grassroots organizations who helped write the initial legislation for Measure T, said, quote, "At its heart, Measure T protects the constitutional rights of people and our community's right to democratic self-governance," end quote. KMUD News caught up with another entity that has voiced opposition to Measure T. Greg Allen, a local attorney, is the vice chair of the Redwood Chapter of Humboldt ACLU. He says that Measure T seeks to limit free speech.
We came out in opposition to Measure T a while back. We have sent a letter to our affiliate in San Francisco to ask the Northern California affiliate to file an amicus curiae brief on behalf of the plaintiffs in the lawsuit.
And so explain to the layperson, what is an amicus curiae that you wanted to be filed, and how would that advocate for the people you're mentioning?
Well, amicus curiae just means friend of the court. The ACLU has filed amicus briefs in many cases where the ACLU is not actually litigating the matter itself. And what we're talking about here would be a brief filed on the legal issues raised.
And what would you hope to have happen as a result of your action?
Whether it's a result of our action or not, we're hoping that the plaintiffs will prevail in this lawsuit. It's filed in the district court in San Francisco. And our basis is because the ordinance, by its very terms, seeks to limit speech. The ACLU has been consistently against any sort of legislation of any kind that restricts the right of speech. An interesting point is I had a chance to take a look at the responsive papers from the defendant on the application for a temporary restraining order, which the court did deny yesterday. And it would appear, on the basis of that the tenor of the arguments themselves, that basically were to the point mostly that to get a temporary restraining order pretty much in any court in the United States, you have to be able to show permanent and irreparable harm. And since this matter is on next week, I believe it's the 22nd, for a hearing on a temporary, actually it's called a preliminary injunction. I think the court probably ruled, how is there going to be? There hasn't been irreparable harm shown for the next week, and I have not seen the court's decision. Don't know what a transcript of it is, but my guess is it's probably on that basis. And so the lawsuit is moving forward. But a point that's worth making is that one of the underlying pillars of this ordinance, such as it is to seek to essentially repeal Section 18 of the California Corporations Code, which, unlike much of the literature that has circulated regarding Measure T, and unlike what we're seeing now in terms of its spokesman, in terms of what they're saying, is that corporate personhood is conferred by state law in California. It's not a matter of something that's done externally. It was actually done by our own legislature in enacting the Corporations Code. And so one of the problems of the ordinance in general is that it seeks to repeal at the local level state law. And it's a pretty clear case of what we call preemption. And it's worth noting as well that the defendants, in their response for the restraining order, which was pretty well done, certainly the folks defending the case appear to be They appear to be very competent in what they're doing and very thorough. They didn't mention the corporate personhood thing at all. That's relevant to this discussion because the ordinance, by its very terms, seeks to make it unlawful under the ordinance for a defendant in a Measure T action to assert any sort of constitutional rights. And in this case, of course, the intention was to essentially repeal from Humboldt County state law. And in the response, there was not a word of this. It certainly suggests that even the law firm defending on this doesn't take that seriously. Our issue really has to do with the fact that by its terms, it limits speech, and the ACLU has always been against anything that seeks to limit speech for anyone. And I think in terms of watching all of this and the byplay that we will have in Humboldt County in the press, it's worth noting that the proponents of Measure T have been very well known for resorting to personal attacks because someone disagrees with their position. And so I suggest to you and to all your listeners, if someone makes a personal attack, it is pretty clear proof that they don't actually have anything to say on the subject matter. They can't really respond to arguments in a way that doesn't include personal attacks. And so as a matter of last resort, then you start making personal attacks. And we've seen a lot of that, and we're actually seeing, I think, kind of the beginnings of it already. Humboldt Coalition for Community Rights, I believe is what it's called. And they sent out letters, as I understand it, to every candidate for every public office in Humboldt County, basically demanding that they take a position on Measure T. And what's really interesting about the stuff that they sent out is that they're doing the same thing that they did 2 years ago, and that is they're equating opposition to Measure T with basically being in favor or intimating that someone who would not be in favor of Measure T would not be in favor of women's suffrage, would be in favor of union busting, and I guess perhaps would be sympathetic to the concept of slavery. And they do this over and over again, and they did it on this particular batch of literature that they sent out. And personally, I think that that's an outrage. That consistently with the terms of the ordinance, what they have tried to do is to stifle free speech. They've attempted to stifle dissent by making personal attacks on anyone who disagrees with their position.
That was Greg Allen, a local attorney who is the vice chair of the Redwood Chapter of Humboldt ACLU. He says that Measure T seeks to limit free speech and that supporters of Measure T are using personal attacks to forward their agenda. KMUD News will continue to follow Measure T through the courts.